The coronavirus pandemic has frozen life for many Americans, just as it's opened up the possibility for state and local governments to exercise a broad swathe of new powers, which leads to the question about whether or not the exercise of these powers is still constitutional. For example, the state of Texas, and along with Ohio, has included abortion as a medical procedure that must be delayed in light of the coronavirus pandemic in order, supposedly, to preserve PPE for nurses and healthcare workers. Now, you might not be surprised to find out that this faced a challenge in Texas. On March 30th, a federal judge in district court in the Western District of Texas imposed a temporary restraining order and said that these clinics could keep on operating. But again, that wasn't the final word. On April 7th, the Fifth Circuit Court of Appeals struck down this temporary restraining order and allowed the abortion ban to be put in place. However, there's still been some more back and forth. On April 9th, the district court judge narrowed his temporary restraining order, saying, well, certain types of abortions could be allowed, including medication abortions. But even that didn't stop this ultimately from briefly going to the Supreme Court, as some petitioners went and filed an application for a stay with Judge Alito. They ultimately withdrew that, as Politico reported just today. SCOTUS isn't going to face this case just yet because the Fifth Circuit has actually eased the pandemic ban. So a lot of back and forth on exactly what the state of Texas is allowed to do. We'll look at that. But we'll also look at another example where the state is kind of going in a different direction and restraining a different type of constitutional right. So back just 2 days ago, Greenville banned drive-in church services ahead of Easter. Now, there have obviously been bans in a lot of places of people actually coming together to gather inside churches for social distancing reasons based on the CDC guidelines. But this Greenville order went even further. It said that you couldn't even do a drive-in church service where you were staying in your car and nobody was within 6 feet of each other. And they still shut down this church service anyway. That led ultimately to the Department of Justice just today intervening in a lawsuit against the city of Greenville that was filed by the church. So both of these are very interesting questions, whether or not these bans on abortion as a part of a ban on elective surgeries more broadly to preserve resources for coronavirus, whether that's constitutional under Roe, and further, whether or not this attempt by Greenville to ban drive-in church services could possibly be constitutional. We'll look at both and analyze both. But first, if you are new here, Human Events started a YouTube channel. We're trying to do rigorous, interesting analysis from a conservative perspective. If you like that, please hit the subscribe button and give us support. The more people subscribe, the more traction our videos get, and the more value, more time and energy we're going to invest into putting out quality YouTube content for you guys to enjoy. So please, if you are new here and enjoy our content on the website, humanevents.com, or on Twitter, please subscribe here on the YouTube. Now, back to the subject matter at hand. So to understand why, let's start with the abortion case. To understand why the original temporary restraining order got struck down, to understand why the Fifth Circuit said, you know what, it's okay for the state of Texas, it's constitutional for the state of Texas to say no elective abortions in the short term, we have to actually understand kind of like what's the legal framework. And that was really explained very well in the opinion that the Fifth Circuit put out on April 7th, 2020. And it just explained exactly what it's like for the federal government and how much authority they have in a public health emergency. So much of this is procedural, but here's where it started. So it talks about the history and what's going on. Our nation faces a public health emergency caused by the spread of COVID-19. As of April 6, over 330,000 cases were confirmed, with almost 10,000 people dead, et cetera, et cetera, et cetera. The president declared a national state of emergency. The governor of Texas declared a state of disaster. So now, skipping ahead, we kind of understand like there was a temporary restraining order put in place. And now the question is, what exact authority does the state of Texas have? Now, as you're probably aware, abortion is, under current law, a constitutional right. States are not allowed to ban abortions flat out. They are allowed to put certain restrictions on abortion based on some detailed case law, but they're not allowed to ban them flat out. So with the state of Texas effectively putting on serious restrictions on abortion, that obviously implicates that constitutional right, again, under current law. So the Fifth Circuit provides this really good way of analyzing what rights the government has in a public health emergency based on a case called Jacobson versus Massachusetts. Now, Jacobson is a very, very old Supreme Court case all the way back in 1905 that dealt with whether or not it was acceptable for the state of Massachusetts to put in place a mandatory smallpox vaccination law. The court ultimately affirmed and said, yes, that was constitutional. But in so doing, the court also explained just how much authority that the government has in a pandemic. Right? The plaintiff said that it violated their 14th Amendment right to care for their own body. The court rejected this claim. And again, in Jacobson, this is the Fifth Circuit retelling, the liberty secured by the Constitution does not import an absolute right in each person to be at all times and in all circumstances wholly freed from restraint. Rather, a community has the right to protect itself against an epidemic of disease which threatens the safety of its neighbors. And in describing, the Fifth Circuit goes on, in describing the state's police power to combat an epidemic, the court explained, in every well-ordered society charged with the duty of conserving the safety of its members, the rights of the individual in respect of his liberty may at times, under the pressure of great dangers, be subjected to such restraint to be enforced by reasonable regulations as the safety of the general public may demand. And what that's ultimately saying is, look, if it's a public health emergency, the government can do things it cannot do at other times, right? If the government were trying to restrict free assembly in normal times, that would obviously be insane. But it can stop gatherings. Like that's lawful, and it's been lawful. And I mean, there's also some other quotations here that are fantastic in terms of the right to practice religion freely does not include the liberty to expose the community to communicable disease. That's probably right. I mean, a really dramatic case, this Caltex case, this quotation is remarkable. That in times of imminent peril, such as when fire threatened a whole community, the sovereign could, with immunity, destroy the property of a few, that the property of the many and the lives of many more could be saved. Again, the rights secured by the Constitution do not disappear, but they can be reasonably restricted. And so then it elucidates the standard. So what is the standard? If you're evaluating an action by a state government, how do you evaluate it for whether or not it's constitutional under Jacobson? Like that, if it implicates some constitutional right. The question is, does the statute, in this case, or an order, purport to have been enacted to protect the public health, the public morals, the public safety, have a real or substantial relation to those objects, or is it beyond that a plain and palpable invasion of rights secured by the fundamental law? So basically what it's saying is you can't use a public health emergency to do anything. If what you're doing has no relation to public health, or if it's beyond question a palpable invasion of rights secured by the fundamental law, then that's going to be found to be still unconstitutional. But that's still a really broad grant of power. Right? It's basically saying unless the government acts in an arbitrary and unreasonable manner, it's going to be lawful. So that's a pretty powerful, statement. And there's other parts of Jacobson that are really dramatic as well. There's one other very good bit from this case that I want to highlight. This is another very, very good line. It is equally true that in every well-ordered society charged with the duty of conserving the safety of its members, the rights of the individual in respect of his liberty may at times, under the pressure of great dangers, be subjected to such restraint to be enforced by reasonable regulations as the safety of the general public may demand. So, rights can be restricted in order to preserve public health. Well, in this case, that seems pretty obvious. Going back to the opinion, to the extent that abortions are a medical procedure requiring medical personnel and medical equipment to do, it's within the powers, the Fifth Circuit said, of the state of Texas to delay abortions temporarily for the purposes of preserving public health, PPE, public health equipment. Now, why did this not go all the way to the Supreme Court? How did the Fifth Circuit kind of restrain itself? So, if remember I told you, after the Fifth Circuit said to the district court, your temporary restraining order, it's garbage. It's okay for the state of Texas to ban some abortions. The district court came back and said, okay, fine. We're still going to put a temporary restraining order in place. We're going to try and curb what Texas is doing, but be a little more selective. So they tried to say, okay, instead of saying all abortions can continue as normal, they're saying, well, certain types of abortions can continue, including, for example, medication abortions. Those are, I think, done in generally the 6 weeks of pregnancy, and they just require, they involve taking specific pills to terminate the pregnancy. That is something that Fifth Circuit had a harder time figuring out could be restrained as a result of coronavirus. So on April 13th, they issued another opinion where the state of Texas was saying, we still want to restrain these medication abortions. And the Fifth Circuit was like, no, you don't really have a good argument for that. And that kind of makes sense, right? There's if it's a medication abortion where someone is just taking a pill, even if that's unconscionable, it's not directly related to the public health crisis, right? There's no loss of PPE. There's no loss of medical personnel that could be used elsewhere. It's literally just a prescription, and that's all. And so, I mean, the idea that this thing banning procedures, medical procedures, could cover something like medication abortion, it pretty clearly doesn't work. And so that's a case where, in general, the government has these broad new powers, can force medical providers to delay providing abortions for a lengthy period of time, even though abortion is under current law a constitutional right up for a certain period. They can't go all the way and say you're not allowed to even take medication to end your pregnancy. They just don't have, the state government can't do that on its own under current law. It's a good example. So now, switching gears, a Mississippi city banned drive-in Easter services, remarkably. That was Greenville, Mississippi, as we saw earlier. The city of Greenville and the mayor ordered on church services and city curfew. This is April 7th. And what they said was they put in place an executive order that ordered all church buildings closed for in-person and drive-in church services. Now, apparently, this is obviously a big problem because drive-in church services don't have any, public health implications. If you're staying in your car, you're not spreading the virus. And yet, so the Greenville mayor is kind of sticking to his guns. He's not going to enforce the tickets, but he's still going to enforce the law, and he's blaming the governor of Mississippi, Tate Reeves, for confusion. This is kind of weird, given that the state's own executive order, which is the one he's relying on, defines churches as an essential business, and it says religious entities, including religious and faith-based facilities, entities, and groups, religious gatherings, provided that they adhere to the CDC guidelines to prevent the spread of COVID-19. So what this church was doing, a drive-in church service where everybody was staying in their cars and the pastor was preaching over FM radio, seems very clearly within what should be allowed. And yet the Greenville, Mississippi mayor was saying it's the governor's fault. If they were wondering what the governor thought, they could check his Twitter account where he applauded the Trump administration and Attorney General Barr for taking a stand in favor of religious liberty. So to understand what happened, the Department of Justice is intervening in this lawsuit. They filed a statement of interest saying what they think the law should be and how it should come out. And they've said pretty aggressively that what the city of Greenville is doing is an unconstitutional violation of the First Amendment free exercise clause. So let's take a look at the Department of Justice's brief to explain why it is that what the mayor of Greenville did was very likely unconstitutional. Like the abortion cases, the Department of Justice starts with the case Jacobson versus the Commonwealth of Massachusetts, again quoting the language, in every well-ordered society charged with the duty of conserving the safety of its members, the rights of the individual in respect of his liberty may at times be subject to such restraint to be enforced by reasonable regulations as the safety of the general public may demand. Again, during a public health emergency, your rights can be restrained if public health demands it. But, as the DOJ points out, the Supreme Court has instructed courts to intervene, quote, if a statute purporting to have been enacted to protect the public health, the public morals, or the public safety has no real or substantial relation to those objects, or is beyond all question a plain, palpable invasion of rights. And it explains, a government can take extraordinary, temporary measures to protect the public, for example, quarantining people, but if it's a violation of the foregoing principles, then a court must grant relief. And how do you look at whether or not it's a violation of those principles? Well, then you start by looking at what does our free exercise law generally say. And it says that people have the right to believe and profess whatever religious doctrine they desire. And restrictions on that have to be what's called neutral and generally applicable. And the case where that was elucidated was a case called Lukumi, the Church of Lukumi Babalu versus the City of Hialeah. It's a really, Lukumi Babalu for short, it's a very odd name, but it's actually one of the more interesting free exercise cases because it dealt with a law that was trying to restrict the practice of the Santeria religion, which allowed for certain animal sacrifices. And this was allowed at the district court and the appeals court levels, but the Supreme Court said, no, you can't pass laws that target religious practice, even if you don't agree with the religious practice or it seems weird. It has to be a neutral law of general applicability. So if you had a law banning all animal sacrifices, that would be okay. If you had a law banning all animal killings broadly, that wouldn't be a First Amendment violation. But if you target a very specific type of animal sacrifice or animal practice, and that is designed to target a specific religion, that runs afoul of the First Amendment. So in the context of what the mayor of Greenville is doing, the problem is that he's singling out a religious institution for different treatment than everybody else. A religious institution doing a drive-in church service is effectively equivalent to anybody just going out in their cars and being at a drive-in, just being in a parking lot, which there's clearly no ban on, or being in a parking lot at a grocery store or a liquor store or anywhere else. The fact that he's subjecting these drive-in church services to this disparate treatment, and that it has no relation to public health, because again, everybody's safe, means that it's a very clear violation of the First Amendment rights. So it's not going to stand up. And so, you kind of have these two contrasting cases where you really start to see like kind of the contours of where the government's power is. In the abortion context, the governor of Texas is allowed to temporarily suspend a large number of abortions, but not all of them, because some of them don't have any public health implications. Things like, are they actually using equipment or doctors that would be going to help stop coronavirus? And then conversely, you can't just ban people from doing drive-in church services, even if you can ban in-person gatherings. Again, because you can only go so far. What you do has to have this internal relation to public health. And sort of intuitively, both of these things kind of make sense. I mean, whatever your views on abortion, I think, and there's plenty of moral weight to questions about whether or not abortions should continue broadly. Whether or not a public health emergency can provide the basis to stop abortions clearly has to do with whether or not that actually helps deal with a public health emergency. And similarly, you can't ban all church gatherings if there's no public health implications for a particular type. There has to be some reasonableness and rationality from government policy. And that's something you find across a lot of areas of the law. Some areas of the law don't really make much sense, but an area of the law as weighty and heavy as emergency law, courts are only going to step in when things are truly, truly unreasonable, because they're a slow branch. They don't want to be getting in the way of what the executive branch does. They're a slow branch of government. They want to be letting the executive handle itself. So that's what I've got for you today. Again, reminder, if you have not already, don't do that. Don't unsubscribe, but hit that subscribe button and get access to all our content when we record it. We're trying to do a lot more interesting, rigorous content like this. I hope you enjoyed it. And if you do, subscribe here and check us out on Twitter and at www.humanevents.com. Thank you so much, and I will see you tomorrow.